This bill updates the Business Corporations Act to keep Minnesota current with best practices in developing norms in corporate governance. The legislation comes from the Minnesota State Bar Association business law section, and it was carefully developed by the Bar Association through a long process that included careful study of recent changes to the Model Business Corporation Act, as well as developments in Delaware, which is the leading state for corporate law. Mr. President, this bill changes the internal governance of corporations, how it deals with shareholders, officers, and directors, and how they interact with one another. It does not deal with corporations' external affairs and how they interact with the public. And there are several provisions in here. I'll just quickly go through some of the highlights. The definition of beneficial ownership is modified to make clear that a beneficial owner includes a person who owns at least 10% of the beneficial interests of a trust or estate, or serves as a trustee for a trust or estate. The bill also sets forth how a corporation can adopt emergency provisions in its bylaws, or if no emergency provisions are adopted in the bylaws, it sets forth the power that exists to act, for the corporation to act in an event of an emergency. The bill also, under the current Business Corporation Act, certain defective corporate acts are deemed void, and there's no way to address them. Under this act, it would provide a process for ratifying or validating defective corporate acts, transactions, and stock issuances. This will make the Business Corporations Act more user-friendly and forgiving and save time and money. It also authorizes for articles of incorporation to highlight the right to adopt shareholder control agreements, and also establishes dissenters' rights for shareholders who object. There's been recent Delaware case law that questions whether a board must approve a final agreement or whether a board can approve an agreement in substantially final form. This bill makes it clear that a board can approve an agreement in substantially final form. It also gives permission for Minnesota corporations to voluntarily exculpate corporate officers for personal liability, except in certain circumstances. This already exists for a board of directors, but this is extended then to make it optional to include officers, and this will bring Minnesota in line with a Delaware practice. Shareholders must approve on this before it goes into effect. It adds equitable enforcement for beneficial owners and holders of voting trust certificates to inspect corporate books and records. Shareholders already have this right under Minnesota law. This just adds those beneficial owners and holders of voting trust certificates. And finally, Mr. President, the bill provides permission for parties to include provisions in merger agreements to allow a target to seek damages against a buyer who has breached an agreement. Those are some of the highlights. And Mr. President, while these changes in the bill maybe aren't very exciting to a lot of people, they will help ensure that Minnesota remains an attractive place to incorporate and do business and create jobs.